John Mullen. The courses are ie411 and ie561, and this is lecture number 3. In this lecture we're going to look at a few thousand years of history with regulation and liability in 75 minutes, so we're not going to go into this in any great detail, but I'm going to give you some idea of where all this stuff comes from and why the heck it's so damn complicated, okay? So let's get started. The roles of individuals, employees, and governments in the workplace safety have evolved over time and will continue to evolve in the future. So here's a brief history, I should say a very brief history, and summary of the current situation. Now we're going to talk about kinds of laws, then some general themes that we've seen over history. What happened in the 1850s, there were a lot of changes and perceptions of what's legal and what wasn't. More in the early 1900s, still more today, and we'll bring it up more or less to where we are right now. And then we're going to talk somewhat about regulation, the different kinds of regulation, and what their status are. So, kinds of laws in the United States. One thing we can look at is where the law comes from. There's basically 3 sources. One is statute law, the second is common law, and the third is administrative law. Independently of that, we can look at the nature of the law itself. There's basically 2 kinds there. One is civil law, and the other is criminal law, more or less. Okay, let's look at these in a little more detail. Statute law, generally this is part of a code of laws. A code is a collection of laws that are kind of organized in some way, have common language and a common goal. So, for example, the criminal code and the electrical code, those are 2 codes that you may be familiar with. These are either decreed by a ruler or generated by a legislative body. And some examples. Code of Hammurabi. How many people have heard of that? Not many, okay. Well, Hammurabi came up with a set of laws, and apparently people weren't following too well, so he put this huge monolith up and put all the laws on it. They didn't have iPods in those days, didn't have the internet, so I assumed that if anyone wanted to find out what the law was, they'd have to hike over to this monolith. Maybe they had pocket versions, you know, where you had to use a magnifying glass. I don't know. But because of this, we have an idea of what the laws were like in 1750 BC, which is almost 4,000 years ago. If you hadn't done this, we would just have to speculate. The Uniform Traffic Code, which is a little more modern, OSHA, and local building codes. These are all statute law. These were all generated either by a legislative body or by some ruler saying, let it be, okay? These things are written down somewhere. They got away from the stone pillar in the last few thousand years. Here's Code of Hammurabi. In case you think that consumer protection is a new thing, if a builder constructs a house for a man and does not make it firm and the house collapses and causes the death of the owner, the builder shall be put to death. That's it's pretty stiff, you know, when you think about it. Probably weren't a lot of people that wanted to build houses in those days, but this covered everything: marriage, the way property was inherited, yada, 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 as they say. I just thought that was kind of interesting because people tend to think of consumer protection as something new. Well, it isn't really. Common law, these are a set of conventions that have grown over time, over hundreds and hundreds of years, based on rulings by judges. And once a judge makes a ruling, it becomes part of common law. And what happens is the judges looking at new stuff, they look at what other judges have said in the past, and unless they have some particular reason not to, they just do whatever that judge did. That's common law. Example is common law marriage, which is recognized in most states. Spouse and offspring may have a claim to the estate of a deceased common law spouse or parent in the absence of a will. And even if there's never been a wedding, there may be rights for the spouse in a divorce. Now, if we compare statute and common, we're looking at proactive versus reactive, sort of. Statutes may be written to anticipate a problem. Now, often they're not. Something happens and we see a new law. But there's nothing to prevent someone from writing a law to prevent something that hasn't happened yet. For example, there's some legislator that's proposing a law to ban the use of human embryos in food. As far as we know, no one has ever done this. But the guy wants to pass a law just to be sure. Okay. They can do that. Common law rulings are always a reaction to a specific case. Judges don't sit around and make rulings in their spare time. They're always making a ruling because somebody has come to them with a specific problem, and they decide how that problem should be resolved. So as a result, common law rulings are always reactive. They can't be proactive. Common law can apply to any legal matter unless it's superseded by a statute. And that could happen before or after. So if a statute's in place and something comes in, the judge doesn't have to look at common law, he can just go to the statute. If there had been a different thing in common law and the statute changes that, the judge has to go by statute law. That trumps common law. For example, in New Mexico, there is no common law marriage. That's because of a statute. And in Texas, common law marriages are restricted, again, according to statutes. You have to meet certain requirements. So it doesn't matter what people had done in the past, because of these statutes, that common law no longer applies. Okay, now looking at the other way, statutes are written by the legislature. They usually lead to a significant change, one way or the other. In theory, they represent the constituents, although sometimes you wonder. Common law is made by judges. It tends to reflect the status quo. Just look at the nature of common law. I'm going to do what this guy did 150 years ago. That's the status quo. It's not, judges are not always representative of the population as a whole, and at times the judges have been influenced by conversations while golfing, duck hunting with their buddies. And there was a famous case a few years ago where a judge did go duck hunting with someone whose case he heard 6 weeks later, and he refused to recuse himself. He said, "Oh no, we didn't discuss the case." So what can you say? All right, so there's that aspect there. All right, I've said a lot of stuff. Any questions or comments at this point?
Do you know what the statute is for why there's no common law marriage in New Mexico?
Well, I don't know the statute number, but I know there is a statute. You could, hey, Google, it would come up. But this came up years ago. There was a guy who died and didn't leave a will, and they were living in New Mexico, and it was a big to-do because he didn't leave a will. Well, as it turned out, he and the woman had lived in Texas for 10 years. So under Texas law, they had a common marriage, common law marriage. Now, New Mexico will recognize the marriage from another state, so because he had a common law marriage in Texas, then in New Mexico they recognized the marriage. Otherwise, it would have been a terribly long legal case. So it's just the way it is. If you live here for a while, you need to realize that New Mexico is not Texas, and Texas is not New Mexico. And I think sometimes they pass laws just to spite each other, okay? So there's a lot of things that there's differences between the two states. Any other question? Yeah, I didn't link that law here, so if you got it, put a post up and then everyone will know. Okay? Thank you. All right. Now, administrative law. This amounts to executive orders. You've heard about these lately. Proclamations. Pardons. Have you heard about this lately? Was it governor pardoned a bunch of people, including some convicted murderers? And everybody's a little upset because all these guys now are out free. But apparently executives can do that. And directives to agencies. The legislature passes a law, but it's up to the administration to have the law followed. And there's usually a lot of leeway in there of how the law is prosecuted, how it's implemented. Anyways, now that's called administrative law. For example, the Office of the President in 2009, Executive Order 13513, Federal Leadership on Reducing Text Messaging While Driving. That was in 2009. We see how much that's worked. And you see here, there's one of the problems with legislative laws, executive law. Sometimes the executive doesn't have as much authority as the executive would like. In 2009, another one, Executive Order 13514, Federal Leadership in Environmental, Energy, and Economic Performance. Another one that, we've been following very closely. Yes. Nevertheless, the executive can make a difference. Now let's look at federal law. There's the United States Code, that's legislation. U.S. statutes at large. Once laws are passed, that isn't the final say. What happens is sometimes people end up in courts saying, no, they meant this, not that, or it doesn't apply here. What is it? Obama was talking about somehow milk got classified as oil, and as fat, oil or something like that, and it was causing problem with the EPA. So he did an executive order. This is when executive orders work very well. When the executive says, don't do that, generally it doesn't happen because people didn't want to do it in the first place. Okay? But anyways, it ends up in the courts, and the laws get modified by court rulings. So that's what we're looking at here, statutes at large. The William Steiger Act, otherwise known as OSHA Act, in 1970, and we'll spend a lot more time on that. Code of Federal Regulations, this is detailed day to day, and it's mostly from agencies, and it's terribly boring, and a lot of it turns out to be redundant because it gets superseded or canceled by something else, which is why they hire lawyers, because lawyers have to keep track of all this. Then there's criminal law, offenses against the state. That always sounded strange to me. It makes it sound like you went to the White House and went like that, But that's what they say. Because the state is so powerful, there's constitutional protections. The proof standard is beyond a reasonable doubt. On the other hand, criminal law, you can end up with penalties, fines, jails, and examples, traffic laws. Okay? Assault, arson, murder, etc. These are viewed as crimes. On the other side, we have civil law. And this involves disagreements between individuals. And in theory, the parties are considered equal. So as a result, the judgment is made on the basis of the preponderance of the evidence. You got 51% on your side, you win the case. Preponderance. Whereas in the criminal law, it was beyond a reasonable doubt, a much higher standard. You can have damages, still can have penalties, but as far as I know in the civil law, they can't throw you in jail, at least not in the U.S. And examples we have are liability suits. We hear about them every once in a while. Okay. And another one that comes up is contract fulfillment. People thought that everything was written down, and then it gets to some point and they realize that they had two different ideas about what was going to happen. And this stuff ends up in as a jurisdiction in civil law. Okay, in criminal law, because the state is so powerful, it's constrained by civil rights. The accused is presumed innocent, at least by the courts. We need guilt beyond a reasonable doubt for conviction. The victim does not pay for investigation, prosecution, etc. We've seen in the papers this isn't true in every country, but it is true in the U.S. On the other hand, you can end up with penalties, fines, incarceration. You can be limited on your actions. Maybe you can't live in certain places anymore. And they might actually execute you in some states. So it's pretty heavy-handed. On the civil law, each side is presumed equal. There's fewer guarantees of rights because they are equal. The plaintiff only needs to show liability in that kind of lawsuit. And there's the preponderance of the evidence. But the plaintiff pays for investigations, court costs, etc., etc., etc. And this is resolved by payments. People pay each other money, or they give each other property or whatever. But they can be punitive fines. If the judge thinks that one of the parties was just pushing their luck and causing a problem, then they can be a fine, and sometimes the fines are more than the damages, which is good for the plaintiff because then they can pay their fees and their lawyer expenses. But not always. So why does this happen? Well, at the time of Hammurabi and in early times, the motivation for justice was primarily revenge. And this has a problem because, as they say, it's an entirely different matter when your ox is gored. People tend to feel offenses against themselves a lot worse than offenses against someone else. So you end up with this back and forth because in each stage the retaliation gets more and more intense because of this difference in perception. So that was where all of this started, but Hammurabi and others realized this is a never-ending cycle. It can go on for generations. It doesn't get us nowhere. So what the laws try to do is to push this down to this level here. And then they focus on something like restoration. This is, many of the early codes focused a lot on this. If you kill a man, for example, and it was found that you didn't do it maliciously, the judge may say, well, you need to support his family for the rest of their lives. They're restoring the income, okay? That kind of thing. In other cases where people just are causing problems, then the courts looked into restraint. So the main idea is to push people away from this destructive cycle here that occurs with revenge, and try to resolve things either by restoring the victim, restraining the actor, whoever it is, or something as a combination in between. Okay? Everybody got that? we get into crimes and torts. Now, torts are not those little pastry with the cream on the top. That's something else. Okay? A willful act against another covered in a statute, by a statute, is a crime. An injury to another that's not willful or not covered by statute is a tort. Now you know what a tort is. The injured party may bring a civil lawsuit, and that's pretty much where we are now. This started way back in the 1800s, and we haven't improved on it terribly. Okay? Any question on that? Lawyers may be necessary, but they're not necessarily liked, as we see. Okay, so as a summary, we can look at laws by the source: statute law, common law, administrative law. We can look at the nature of the law: civil law, criminal law. There's another dimension I don't have here on the source. And we can look at federal law, state law, county law, local community law, etc. There's lots of laws out there. Now remember, what we want to do there, the whole idea is to take the revenge and replace it by restoration, restraint, or both. Okay, any questions or comments at this point? You are not ready to pass the bar. Okay. All right. Now let's switch from this general classification of law into liability, which is really the engine that drives a lot of changes in the law with respect to safety. I'm going to have a lot of terms. One is strict liability, negligence, privity, legislated liability, workers' compensation, strict liability again, limited liability, and excused negligence. This is basically the turning points in the law with respect to personal and industrial safety. Now, strict liability, the concept is if you cause an accident, you're responsible regardless of the circumstances. Code of Hammurabi, right? Examples. Code of Hammurabi. Hey, I saw that somewhere. Implied warranty. Blood law. Nothing to do with vampires. Implied warranty. Presumption. One may assume a product that you buy is safe to use. If you buy a coffee maker, it's reasonable to presume it will not burn down your house. Okay? Manufacturer must assure that safety by whatever means are considered reasonable. Manufacturer must have a safe design, manufacture the product correctly, transport the product to avoid damage, and assure the customer uses the product safely. That's why you get these long little booklets with all the different cautions. How many people have gotten those booklets? How many people have read those booklets? You see the flaw in the plan, right? Okay. So, anyways, that's the status. Now, blood law, if the person caused the death or serious injury of another for any reason, that person's life was forfeit unless it was classified as a misadventure. I think we'd call that an accident nowadays. Misadventure. Accident, no intent or fault. Generally, you end up settling with the relatives. Restoration now. Might agree to support somebody. And in some cases, you may need a pardon from the king or the Lord. And if you just look at that for a little bit, you realize that if you're wealthy, it's more apt to be a misadventure than if you're dirt poor. But anyways, that's how it was on the books. Then in the 1800s, there was a relaxation of strict liability. You had to show that the injuring party was responsible due to some lapse of practice or judgment. Of course, this is open to interpretation, and you could assume if it's in a factory and a person is injured because, let's say, a press blows up, the employer could always argue that the worker should have known the press was going to blow up. That kind of thing. By 1850, you had to show the plaintiff had not contributed to the accident or injury. So, if the employer was 99% responsible for the press blowing up, but the operator was 1%, then the liability case would be thrown out because of contributory negligence. Okay? This is the 1800s. What do we mean by interpretation? Here's an example of interpretation. It would cost less to bury a man killed in an accident than to put air brakes on a railroad car. This was 1893, an executive I won't mention, when he was testifying against the 1893 Railroad Safety Act, which required safety couplers on trains. That's what you call interpretation. Put that in a little bit of a context. This is from Occupational Safety Management Engineering, who's by a guy named Willie Hammer. That really is his name. Okay. Anyways, this is the number of trainmen injured or killed per 10,000 employees. And this up here is the total number, starting back in 1893. And this is trainmen killed in accidents other than coupling. And we see that goes from about 600 to about 1,200 over the, let's see, 10 years here. But look what happens to trainmen in coupling accidents. And you can see pretty easily that legislation addressed that issue, but didn't do much for anything else. Okay. Legislation required the railroads to put on safety couplings, which did not require the trainmen to be between the cars when coupling and uncoupling them. Okay. At this time, there were 176,000 people working, and 10 years later, there were 317,000 working. So even with the increase, roughly doubling, almost doubling, very few people now were being killed in coupling accidents. But the rest of the train business was still pretty dangerous. Okay? That's interpretation. In 1850, there was a thing called assumption of risk. And here's the theory. If you take the job, you must feel it's safe. Otherwise, why would you take it? This ignored the reality that people needed jobs to feed their families. And it also assumed that the employee would be able to see what the danger was. And you can bet the employers weren't educating them on this matter. Another one was the fellow servant rule. If an employee is injured by another employee, it's not the employer's fault, even if both follow the guidelines and the training set down by the employer. So, and they had one case where a conductor accidentally loaded explosives on a train that traveled through 3 states and blew up in the middle of a cow pasture and killed a brakeman. And they said because the conductor put it on the train, the railroad was not liable. The conductor was the one who caused the accident. Anyways, that's how it was in the 1850s. A little more. Privity. How many people have heard of privity? Yeah. Privity is the idea that, okay, if I sell you something, privity exists between us. But if I sell you something and then you sell it to her, Privity exists between you and her, but not between me and her. Okay? We have had to add an exchange of money and property to have privity. So you couldn't sue your employer because the employer didn't make the press that blew up. You couldn't sue the manufacturer of the press because he didn't sell the press to you. He sold it to the manufacturer. So you couldn't sue anybody. There was no privity. The same principle applied to defects in cars bought from dealers, and in general, the thing about the car with the dealers is the car company would sell the car to the dealership would sell the car to you, therefore there was no privity between you and the car manufacturer. Nowadays this is different because car manufacturers tend to not sell cars to dealerships anymore. Instead, it's like a commission. But back then, that's how it worked, and there was no privity. So we had some, I say, recent legal milestones only 100 years ago. 1916 is McPherson versus Buick. As far as I know, McPherson has nothing to do with the struts. This killed the basic privity argument. And then in 1960, Hennington versus Plymouth Motors, this led to the idea of implied warranties, which hadn't existed up to that point. And then in 1969, Elmore versus American Motors, this extended the liability to third parties, which certainly had no privity. So let's look at the first one. This is McPherson versus Buick. In May of 1910, McPherson buys a Buick from Close Brothers dealership in Schenectady, New York. I think that's how it's pronounced. In July of that year, the left rear wheel collapses, the car overturns, and traps McPherson beneath the rear axle. He had very serious injuries, lots of pain, loss of sight, permanent disability, can no longer work as a stonecutter. So, in September of 1910, McPherson sues Buick. And the claim is that the hickory spokes in the wheel were rotten, and this caused the wheel to collapse. Yes, they made them out of wood in those days, which led to the accident and injury. This is similar to an earlier lawsuit, Winterbottom versus Wright. There was a wheel collapse and injury. There was a ruling by Lord Abinger in 1842, and his ruling was no privity between the manufacturer and the victim, and so the case was dismissed for lack of privity. And what did that ruling do? Common law. It became part of common law. Even though this law was not, this case was not settled in the U.S., common law is common law. So that was the principle that was in effect at that time. So here's Winterbottom. There's Wright. He sells the coach to the British postmaster. There's privity. He issues the coach to Winterbottom. There's privity there. Winterbottom gets injured, but hey, the postmaster didn't cause the problem. Wright caused the problem. The British postmaster, well, he wasn't injured, so he has no reason to sue Wright. So the case was thrown out because there was no privity between Winterbottom and Wright. No contract, no exchange of money and goods between them. So now, in the workplace, what this means is if the manufacturer causes a defect and sells the item to a factory owner, there's privity, and then issues the item to the worker, there's privity. The worker gets injured, can't sue the factory owner because the factory owner didn't cause the defect. Factory owner is not injured, can't sue the manufacturer, and the worker can't sue the manufacturer because there's no privity. That was the status at the time of this automotive lawsuit. So, McPherson comes along, and this is exactly the same situation. Here's McPherson, he's injured, he has privity with the Close brothers, but they didn't cause the defect. Close brothers aren't injured, they can't sue Buick, which caused the defect. There's no privity in here, so McPherson can't sue Buick. But he's a McPherson. He's not going to let that stop him. Besides, he's disabled. He's got lots of time on his hand. So what else are you going to do, right? So he sues Buick. So in 1910, the first trial was dismissed for lack of privity. That was common law. McPherson appealed and got a new trial. So in 1913, a jury awards McPherson $5,025, which doesn't sound like much, but in today's money, it's $109,430, which is a lot more money, but still not much for someone who's permanently disabled. Nowadays, it would be like 10 or 20 million, right? Okay, anyways, that's where it is. Buick, of course, appealed, and they lost in January of 1914. When did this happen? Let's see. 1910. So it's been over 3 years. And Buick appealed again and lost in March of 1916. So, what happened? Well, there were legal expenses for 5 trials or appeals. This was a big problem for McPherson. No problem for Buick. They had those lawyers on retainers. They paid them whether they worked for them or not. The matter was in the court for 6 years, during which McPherson could not work. Actually, he couldn't work after the 6 years either. The final award was substantial. You know, what was it again? 109,000, somewhere between 109 and 110. But it's not much because of all the pain he went through, the loss of livelihood. He probably had medical bills. So he won, but it wasn't a great victory for him. But this rejected the privity argument. Privity argument was no longer the resolution of this issue in common law. This had a tremendous impact. In the first appeal, the court said that Buick owed a duty to all purchasers of automobiles to assure the cars were reasonably fit for normal use. He wasn't going cross-country, he was driving on the road. In the second appeal, Buick is not at liberty to put a product on the market without checking component parts with ordinary and simple tests. At that point, I think Buick gave up because they didn't want to see what the third judge would tell them. Because it seems like every time they appealed, they ended up worse off. So this really constrained them a lot. So, half a loaf. McPherson versus Buick, limited success in the workplace. Operators could finally sue equipment manufacturers, but not workers who weren't operators. So if the press blew up and somebody from quality control was walking by and got injured, that guy couldn't sue because that guy wasn't operating the press. And if somebody was just a bystander, that wouldn't work either. And they also had to show some negligence on the part of the manufacturer. And there was negligence in the McPherson case because the wood was so rotten that all you had to do was look at the wheel and you would have known that's going to be a problem. Okay, more on privity. In 1969, Elmore versus American Motors. How many people remember 1969? We're getting into the modern era. People were alive then. Okay? Mrs. Elmore's American Motors car failed, caused her car to strike another car, and killed Mrs. Waters, who was driving the other car. American Motors unsuccessfully argued that they were not liable since Mrs. Waters was not an operator or even in their car. They were in someone else's car. Remember the argument? You had to be an operator. The courts didn't buy that. So this extended liability to all who could be injured on the road or in the workplace by faulty equipment. A little bit more. Implied warranty, that was in the McPherson case. Let's see. Where was it? Their first appeal, January 1914. The implied warranty means that the customer may assume the product is safe for ordinary uses, and the manufacturer must assure the item is safe. I always have trouble with this. Anyone here have a bicycle? Did you ride how many people rode bicycles as kids? Yeah, okay. Do you remember all those warnings that came with it? How many people use that as a checklist? Oh, I did this one today. Yeah. If you look at the ads on TV and compare them to the cautions that come with the bike, the people in the ads are actually violating the cautions. So they're clearly marketing a product and presenting an idea that it's one kind of use, but if you read the documentation that comes with it, they're implying a different kind of use. As far as I know, this hasn't been resolved. But anyways, that's the situation there. Contributory negligence, even if the victim is partially responsible, the court said, yeah, well, okay, you're still 99% responsible, so you're still going to pay 99% of the damages. Okay? And this applies in the workplace only. Now, this is like a pendulum, and we swing a little further, and we get, like many and several, commonly called deep pockets. How many people are familiar with this? Okay, you ever notice that when a lawyer sues, they sue everybody and their cousin? Anyone who might be remotely responsible, okay? This is why. If several defendants are partially liable, but not all can pay, the share of each payments may not correspond to their share of the blame. This caused a problem for Cessna some years back, because there were a number of lawsuits where they were like 3% liable, 5% liable, but no one else that was sued had any money, so they'd end up paying all the damages, or almost all the damages, millions of dollars. So for a while they were seriously considering to get out of the airplane business because they couldn't afford it. So this is called deep pockets in the press, and lawyers call it many and several, and that's why they sue everybody. Strict liability, whether the problem is design, manufacturing, and distribution, if there is a manufacturing defect that causes the problem, you do not need to show that the manufacturer was somehow negligent. In McPherson, he had to show that this was a defect they should have detected. Nowadays, because of strict liability, coming back again, that means that the fact that it failed is evidence that something went wrong, and you don't have to show that they goofed up. Okay, that's where we are there. That was a lot of stuff. Any questions and comments?
So there's no more privity? Or there's no...
Well, as far as liability goes, privity, a lack of privity is no longer an accepted defense. Now, I'm not sure if privity doesn't apply in some other venues, but at least in safety, it's no longer a defense. But 30 years from now, who knows? It might come back, because these things go back and forth. Remember, we started with strict liability, and we ended with strict liability, although not the same strict liability. Okay. Legislation doesn't have to wait for a lawsuit, so it can be proactive, but it's inspired by events. For example, the Brady Bill. How many people remember the Brady Bill? Okay. Somebody tried to assassinate the President of the United States, and Brady was with the President, got badly wounded, People got real upset like this, so they passed a law to control guns. The problem with the law is it would not have prevented the crime. But because public opinion was sensitive to this issue, they were able to pass the law. So you can say it's proactive. So if you think about this, this means there's people out there with laws waiting to pass, just waiting for something to happen so they get the leverage they need to pass them. So that law would not have prevented the crime. So in a sense, it's not really proactive as far as we know. We don't know, however, how many crimes it has prevented. There's no way to know, and that's one of the problems with being proactive. Legislation is limited by the Constitution. The government has more resources, can fine, incarcerate, or even execute people, and if you didn't have the courts and the Constitution, things could get out of hand. But things are not always as easy as they look. This is the 14th Amendment to the Constitution. Looks pretty straightforward. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, I'll leave without comment that apparently certain people have not read this because we've had some laws passed recently that clearly violate part of this amendment. The courts will sort that one out. It's not a safety issue. Now, the 14th Amendment, its intent was to assure rights to former slaves, but it's had a side effect. It has strengthened the rights of employers to keep government out of their business. A factory is private property. It says in there, equal protection of the laws, not deprive any person life, liberty, or property without due process of law. So this has made it very hard for the government to go into a factory and say, that's not safe, stop doing it. It still has an impact today. There are some factories which have never had inspectors in them. They're private property. And this requires the government to use a carrot and stick approach. They've got to try to get people to agree to let this happen. And the wild card is public opinion, because no corporation can do well if the public decides it's a nasty corporation and they're going to get their stuff elsewhere. Back to strict liability, the tort system is ineffective. It's time-consuming and costly. Remember how long it took for McPherson and how much it cost him. The plaintiffs are not really equal. I mean, McPherson comes in with his lawyer. Buick comes in with their 14 lawyers. There's no real equality there. Strict liability improves this by reducing the burden of proof. You don't have to show negligence. Unfortunately, it differs from state to state. A lot of this is done by state law, not by federal law. And some states have caps on awards. So even if you win, you can only win so much. Questions? Comments? All right, so let's look at how all this fits together. We have executive orders, regulations, and legislation. Then there's civil laws. Civil laws, under them, if we have a tort, we can go to court about this. Regulations, so civil laws indirectly affect workplace safety. Regulations directly affect workplace safety, as far as the 14th Amendment allows them to. Legislation becomes regulation. You don't experience laws directly. You instead experience it through regulations. Executive orders also experience it. Lobbyists have this habit of influencing executive orders and especially legislation. What's the ratio in D.C. now? I think it's something like 50 to 1. Each legislature has 50 lobbyists trying to bend their ear. And they're and have an effect, but people get elected to office in this country, so if public opinion gets strong enough, it can trump the lobbyists and either cause legislation or executive orders to affect anything, including workplace safety. And public opinion can also affect civil law, as we saw in that McPherson case. The civil law ruling was just ignored in the jury trial. And that's probably why, because it was a jury that made a decision, not a judge making a ruling. So all of these things interact, and because they interact and push on each other, you can pretty much bet that this is not going to settle down anytime soon, which means that if you're involved in regulation or law or anything, you really have to keep up. Because what you could do last year, you can't do anymore, maybe. Or maybe something you couldn't do last year, you can do this year. So you really have to keep your ear to the ground to see what's going on. Okay, current status. The federal government regulates most foods and drugs, has jurisdiction in some health issues, some jurisdiction in environmental issues, and extended jurisdiction in national security. I mean, if someone in government gets mad at you, they can say, oh, you're a threat to national security, and you're done for. Right? That's the biggie right now. But it still has limited access to workplace. Basically, employers have to say, yeah, you can come in. They often do this, the carrot and stick, for example. They might have as a condition of a federal contract that your facility be inspected. So if you want that contract, you have to agree to that condition. Okay, and enforcement varies tremendously from place to place and state to state. State and local governments, they regulate construction and other things, use of things. They look at fair labor practices. They look at workers' compensation, which we'll talk about later. But this is something that takes care of somebody if they get injured on the job. Big one is fire safety. That's probably has more attention than anything else. But they still have limited access to the workplace. Laws and enforcement varies from place to place and even from type of operation to type of operation in the same place. And enforcement, well, we're in a depression or coming out of depression, and sometimes what they do is they cut the budget for inspectors and enforcers of these rules, so the rules are still on the book, but nobody is checking them and no one's making sure that they're followed. That's of right now. 5 years? Okay. The need for regulation. As we mentioned in the last lecture, there's this unfortunate trade-off between profit and safety. If you want to be safe, you'll have less profit, in the short run anyways. And if you are willing to cut corners in safety, you'll get bigger profits for a while anyways. Okay, and I mentioned this time the Exxon Valdez. Anyone remember that? Yeah, okay, most people remember that one. Technological innovation causes regulation needs. And for an example there, I'll use airbags. Everybody knows about airbags, right? In cars. Anyone have airbags in your car? How many airbags are in your car? Only one. Got an older car. Nowadays, someone's advertising 17 airbags in their car. Going, wow, where do they put them all? Okay, information overload. So, and for that, I'm going to talk about electrical specifications. Exxon Valdez. March 24th, 1989, Alaska, Prince William Sound. They dumped 11 million gallons of oil, crude oil. This gave us a site that was about 2,600 square miles. It was then the largest oil spill in U.S. history. 10,000 Alaskans sued Exxon. 10,000. Man, that courtroom must have been huge. For $1.5 billion, Exxon Corporation was judged reckless, and Captain Hazelwood, remember Captain Hazelwood? Yes, he was ruled negligent. But Captain Hazelwood doesn't have $1.5 billion, so you know who they're going after. They're going after Exxon. There were a number of problems with the Exxon Valdez. It had a single hull. So that means is what you see on the outside of the ship, on the other side of that same piece of metal is a tank of crude oil. Very small crew. I forget exactly, it was either 12 or 14. The captain had a drinking problem. Well, he didn't have a problem drinking. He had had 3 vodkas just before sailing. So he left an inexperienced operator alone on the bridge. Whoops. I'm having trouble with the mic. Left an inexperienced operator alone on the bridge. They were in dangerous waters. The computer kept telling the operator, no, you don't want to do that, and kept changing the commands. And the operator didn't know how to get the computer to behave. And once it was grounded, the captain attempted to unground it. His philosophy must have been, well, if we get out of here, no one will notice. Okay? Well, he had 3 vodkas. I mean, what can you say? This was pretty bad. This is a well that was dug by Temple engineering students in 2009, and they just left it for a little bit, and it filled with oil. So in 2009, let's see, that was 1989, 20 years later, there's still a lot of oil under the ground in the area. It's not going away. Even today, the beaches are still contaminated. They estimate about 20,000 gallons of crude oil is still there. That's after the cleanup. The good thing was we ended up with better regulations, one of them being that if you're going to have a ship carrying oil go through the Sound, it has to be double hull. That way, if the hull is ruptured, the oil tank is not. But then we had the Deepwater Horizon disaster. What can I say? The Deepwater Horizon, the rig exploded and led to a leak that lasted 3 months. That's in 2010. 11 workers died and 17 were injured. It released about 5 million barrels of crude oil into the Gulf. And people are still sorting that way. Of course, that wasn't a ship, and it was in the Gulf, not in the Straits. So you could argue it was a different situation. But other people could argue, yes, but it involves crude oil, which is the same stuff going into water that has things living in it, which is the same situation. And this is the problem with reacting to things. It's the scope of the reaction that you can't always control. Okay. Any questions, comments, please? Okay. Here's another one. Automotive airbags. Since 1994, every car has either had an automatic belt or airbags. Anyone been in a car with an automatic belt? Yeah. They didn't last long. People have settled pretty much on the airbags. The driver and the front passenger. Originally it was the driver, then it became the driver and the front passenger, and now they got 15 other airbags around somewhere. The original specification was to protect unbelted passengers and the bags expand at 200 miles per hour. So you run into a wall at 30 miles an hour, and you end up with an airbag coming back at you at 200 miles an hour. That is supposed to be an improvement, though. Okay. Now, actually, the early results, they estimate that between 1986 and 1999, airbags saved 3,500 lives, but during that same interval, roughly, it killed 52 people, airbags, 32 of which were children. Now, if you want to kill a project, just have it kill children. People will get turned off on it very quickly, and you can't blame people, right? We don't like that. More current results, 2008, the estimate now is up to 28,000 lives, but 290 people have been killed in low-speed crashes. In 90% of the cases, they weren't wearing belts, but, you know, with little kids, they've had things like people put the carrier in the front passenger seat and arrange it so when that 200-mile-an-hour airbag hits it, it actually causes a problem for the child. But nowadays, most people know you keep the children in the back, etc. But 28,000 lives saved, 290 lives lost. It's an improvement unless you're one of the 290 or know one of the 290. And this is a problem. When we change things, we change things. We have the intended consequence, 28,000 lives saved, but we also have to face unintended consequences, the 290 people killed. And that's what makes it tricky. Okay. Coping with bags, children in the back, they now have smart shut-off switches that will turn off the airbag unless an adult is in the front seat, passenger seat. Presumably you'll have an adult in the driver's seat. Okay, they got smart sensors. They got cautions now, which probably nobody reads. Have you noticed the cautions with the side airbags? What are the side airbags? What do they warn you about there? I don't remember. Don't lean your head against the glass. Anyone have any kids? What do they do when they get tired? They lean their head against the glass. So we may have troubles with them. But because they come out the side, if your head is against the glass, they're going to come down and hit you on the top of the head. Okay? So, you've got to read the cautions. The changes have changed, regulations have changed. The design of the airbags has changed. They now have multiple stage inflation. They introduced them first in Canada and then into the U.S., and by 2008, these were mandatory. So if you have a car that was manufactured 2008 or later, it should have these safer airbags in them. If you have an older car, be careful. Questions, comments, anything? Okay, so why do we have regulation? One is uniform operation. You know, you can get into any car and pretty much drive it. Anyone here rent cars as part of traveling around doing business? It takes maybe 60 seconds, 2 minutes to figure the car out and you can go off. Why? Because a lot of what's in the car is there in a certain way because of regulations. Also, regulations try to give us a safe use of technology. Remember, electrical outlets used to have the prongs coming out. Now they all go in. Someone figured that out pretty quickly. Oh, this is a bad idea. Okay. We're on a consistent level of safety over all things, as much as we can. We want to have a safe design that's fairly simple, because the more complicated it is, the more likely we're going to have trouble. want to reduce ambiguity in certain situations so people know what to expect, and sometimes the regulation is just getting a bigger stick to beat on the manufacturers or the factories with. They come from the federal government. Code of Federal Regulations is 50 topics in there. If you're bored at night, you can look at that. These laws are modified by district courts and by executive agencies. There's state regulations, local regulations. There's voluntary consensus standards. Believe it or not, manufacturers and other business owners volunteered to be put under standards that are not required. What's the primary reason?
Publicity.
That's part of it, publicity. They don't want laws. So if they can agree to a voluntary set of regulations, they don't have to worry about a law being passed enforcing those regulations. So that's another reason. And then we have foreign, like NAFTA, was it North Atlantic Free Trade Agreement. Because of that, things that are sold in North America and sold in Mexico have to have the same rough standards as far as safety goes. Otherwise, we can't freely trade them in the two countries. Okay. Even on the handout, you can't read this. Okay. This is Occupational Safety Management Engineering 5th edition by Willie Hammer and Dennis Price. This here lists all the organizations that have voluntary standards for the chemical industry. And up here are all the activities that go on in those industries. And what you see in the middle here is this activity is regulated by this organization. Any chemical engineers in here? Yeah, I wouldn't either. This is driving nuts, okay? Chemical industry is very highly regulated, as you can see. These are the different organizations. You don't really need to memorize them all. Here's some of the groups we have. ANSI, American National Standards Institute. That ring a bell with anyone? ANSI? Yeah, good. ASTM, American Society for Testing and Materials. NFPA, National Fire Protection Association. Really, really big organization. Underwriters Laboratory, ever see the little UL symbol? Okay. NSC, National Safety Council. These are all non-government organizations. Then you have insurance companies. Remember we talked about the boiler company, boiler insurance? You do this with your boiler, we'll give you an insurance policy. You don't want to do it? We're not giving you the policy. That kind of thing. American Insurance Association, Factory Insurance Association, Factory Mutual System, Oil Insurance Association, and that's everything but painting, coating, noise, vibration, lubrication. But all of these work this carrot and stick thing saying, you want our policy, you have to do this. If you don't do this, we won't sell you a policy. And people want the insurance. So that comes in. And then there's professional societies. And how about that? Recognize any in there? Yep. See? They're all involved. It's technical and trade groups. There's about 18 of them altogether. That takes care of everything but insulating and fireproofing, dust hazards, and double clicking. Yeah, radiation exposure. There we go. There's other groups that take care of that. The U.S. government, oh man, alphabet soup. Bureau of Mines, Department of Transportation, U.S. Coast Guard, Hazard Material Registry Board, Federal Aviation Administration, Environmental Protection Agency, National Bureau of Standards, U.S. Fire Administration, Occupational Safe and Healthy Administration, and probably a dozen more that I couldn't fit on the slide. And then on top of that, we have state county, city. Depending on the location, we look at the size of exits for fire codes, storage of materials for about 5 different reasons, the way things are constructed, et cetera, et cetera, et cetera. So what comes up? Well, we got all these people involved, so one of the questions is, who has jurisdiction here? Okay, I'm pumping oil, but I'm on a station in the middle of the ocean, or in the middle of the Gulf, right? What rules apply? What happens if 2 different standards say different things? Who do I go with? We could go with the minimal standards. That probably won't fly, though. Things are subject to change. This is better now that we have the internet, because you can go out and go to these websites and get the latest. It used to be a big pain when things were printed up, because you'd always have to check, and you'd get these little, you'd read the book, and then you had to read these extra sheets at the end, which show the changes since the book were printed. Big pain. Consensus standards, things are iffy there. That can change. And one big problem with regulation is people think that if they follow all the regulations, they're safe, but that may not be true, because something might be going on that isn't covered. Let me show you what I mean. Electrical exams. Now, inside of a lot of electrical equipment, they have these things called capacitors. And while the equipment is operating, they can get very high voltages on them. So, before you work on this, what you need to do is you need to make sure that there's no residual charge on the capacitor, because if you touch them, you can receive a dangerous shock. Okay. So, Mill Standard 454. This requires that any capacitor that you have in your equipment, that the voltage is reduced to 30 volts or less within 2 seconds. IBM standard is 60 volts in 10 seconds. Now, Mill Standard applies to military equipment. IBM, well, if you're building something for the military, if IBM's doing it, they have to go with Mill Standard, but if they're not, then it's 60 volts in 10 seconds, which is a much more lax standard. National Electrical Code, if the capacitor is less than 600 volts on it, it has to be reduced to 50 volts in 1 minute. Oh, we're really going bad. And if it's greater than 600 volts, 50 volts in 5 minutes. Okay? All right. Underwriter Labs, 50 volts in 1 minute, regardless of what was on it to begin with. So what does ANSI say? Just ground them. Don't take any chances. Just put a probe on them and make sure there's no voltage, because who knows what standard was followed when they set this thing up. You see the problem? If you go into court, they could say, well, we established the National Electrical Code, that's what we used. Yeah, but the guy is still injured, We can't change that. Now, UL, what people may not know, that Underwriters Laboratory only approves the design, not the manufactured product. So, between 1970 and 1977, 200,000 TV sets caught fire that were UL approved. There was a vaporizer that scalded children. That was recalled. There was a charcoal lighter that killed users. There was a toy oven that reached 660 degrees Fahrenheit. That's supposed to be a degree symbol up there. There were 15 different heater designs that were not acceptable. And this was really cute. There were smoke detectors that caused fires. Okay, all UL approved. Now things have changed. They've gone to color coding. So if you have an extension cord that's green, that's for indoors only. If it's red, you can use it indoors and out. I thought it was just Christmas stuff. The designs are getting better, but we have a problem. That now there's devices that say they are UL approved, but aren't. 60% of the ones that have been identified so far are from reputable sellers. Sears, Penny's, Kmart, Target. They don't know that they're counterfeit. And in fact, it's often difficult to tell that something is counterfeit. So we have the regulations, it's in place, but that's still no assurance that things are safe because there are some people that work around the regulations. Any questions or comments?
Does UL still only do design?
Excuse me?
Does UL only do design still?
Yeah, UL still just approves the design. So you do have a problem that the manufacturer may not follow the design exactly. You know, that's the difficulty. Still, it's better than nothing. The counterfeit stuff is definitely causing more trouble than anything that was legitimate. Any other questions? Okay. Well, I've got a review here, but we're about out of time. So when you get a chance, just go through, and you can get everything on one sheet there to remind you what we talked about. Here's the links. Again, these are too small to read, but on the notes, online notes, if you click on them, it will open a web page. And then for next time, Lecture 4, we're going to talk about workers' compensation, which is a very specific thing, and OSHA, which is another specific thing, both of which greatly affected the way people work in the workplace nowadays. And you can read about these in chapters 6 and 8 of the text. No questions? We're done.